Restrictive covenants can be tricky when you're hiring employees, or if you try to get people to sign non-compete clauses, non-solicitation clauses after they've already started. Now in Florida, it's an at-will state, meaning you can hire and fire people at will, as long as you don't violate federal and state discrimination laws and some other rules like that. But generally you can hire and fire people. So you could go to an existing employee and saying, as a condition for continued employment, I need you to sign these documents. Now, depending on how critical that individual is to your business and how much power they have, if they refuse to sign it because they don't want to be under a non-compete, they feel like that's threatening to them or it limits their opportunities, then you have to make a business decision over whether protecting your company against this employee leaving and competing directly with you is more important than retaining the employee in the first place or getting to hire them in the first place. So that can be a tricky decision. Generally, I definitely recommend that people have non-solicitation of customers and employees and non-compete clauses in their contracts with their employees, at least in the state of Florida. One reason is that if you go to sell your business or you want investors in your business, they are going to want to know that your key people can't just go and open a competitive business down the street. Now, even without these terms in your contracts, there are some protections under state statutes and state laws called trade secrets protections. So it's still unlawful for someone to steal your trade secrets and go use those in competition with you, but that's a much harder thing to prove and a higher standard to meet. If you can have the non-compete clause and the non-solicitation clause in the employment agreement in the first place, it's superior. So you should try to do it.